Good afternoon. If I could ask anybody who's still getting pizza to grab your pizza and grab a seat, and we'll get started. Welcome to the latest installment in our Distinguished Speakers series. It is my great pleasure to introduce today's distinguished speaker, Professor David Harris, and welcome him back to the law school. As you will hear, he has many claims to fame, but for me, the most significant is that he was a member of this law faculty from 1990 to 2007, when he moved to the University of Pittsburgh, where he is Distinguished Faculty Scholar, Professor of Law, and Associate Dean for Research. If this was 5 years ago, he would need no introduction, but let me tell you a little about him. A graduate of Yale Law School and Georgetown Law School with an LLM, he studies, writes, and teaches about police behavior and regulation, law enforcement, and national security issues. He is probably the leading national authority on racial profiling. His 2002 book, Profiles in Injustice, Why Racial Profiling Cannot Work, and his scholarly articles in the field of traffic stops of minority motorists and stops and frisks influenced the national debate on profiling and has led to federal efforts to address the practice and to legislation and voluntary efforts in over half the states and hundreds of police departments. Professor Harris has testified 3 times in the United States Senate and before many state legislative bodies on profiling and related issues. He has appeared on The Today Show, Dateline NBC, National Public Radio, and has been interviewed by the New York Times, the Wall Street Journal, and many others. Professor Harris's 2005 book, Good Cops, The Case for Preventive Policing, uses case studies from around the country to show that citizens need not trade liberty for safety. They can be safe from criminals and terrorists without sacrificing their civil rights if law enforcement uses strategies based on prevention. He gives speeches and does professional training for law enforcement, judges, and attorneys throughout the country. He told me this morning he's in an effort to work with law enforcement and community members in Pittsburgh to defuse tensions there. Professor Harris's latest book is Failed Evidence: Why Law Enforcement Resists Science. It takes on a new but equally important topic that will be the subject of today's presentation. It will be available for purchase and signature afterwards. Anything David Harris writes is insightful and provocative, and I look forward to hearing about failed evidence. It has been my great pleasure to have known and worked with David Harris these past 20-plus years, and to have shared adventures with him from here to Hungary, where we have taught together at the University of Szeged. I am delighted to have him back. Please join me in welcoming my good friend, David Harris.
Thank you. Thank you so much, Dean Steinbach. My good friend Dan Steinbach, what a pleasure to be introduced by him, and what a pleasure to see so many of you that I have known for some time, and to meet many of you who I'm just acquainted with. And it was so nice of you to redo the auditorium just for me. It really looks great. Thank you so much. I am delighted to have the chance to come back and speak with you here today about some new work. It has filled my last few years, made me busy, enthusiastic, outraged, and all the other good things, almost all at once. So let me introduce you to the book Failed Evidence. Here we are. Okay, so if you look around you today, almost anywhere in the media, in entertainment, movies, anything you want, you would have the distinct impression that law enforcement and science are in a 21st century partnership, that these are the golden days being born. You could look at entertainment, right? And you would see CSI and its innumerable clones, and you would find that the image on the left side of the screen in which the police officer is handling test tubes and DNA and other gadgets and so forth. Much more common today than the old hold the gun, cuff 'em up, book 'em Dano stuff of 25 years ago. But you wouldn't stop at entertainment. You could look in any newspaper any day of the week and see headlines like this. Here's a random Google search. DNA match leads to cold case conviction in 2003 sexual assault. You could see this anywhere, anytime. So you'd get the idea that science is now the handmaiden of law enforcement, that they are working together. But that's really what I want to ask as a question, not tell you as a statement, because I'm not so sure, because I see something a little different when you pull back and look at the larger picture. Not really the way it's portrayed. DNA, sure. Chemical analysis, yes, this is solid science and it works very well. But when you get beyond that and you start to look at the increasing, the years, the decades of science that there is out there on much more basic police work, things like eyewitness identification, like interrogation of suspects, and more basic aspects of forensics, everything from fingerprints to bite marks, you get a much different picture. In those areas, law enforcement is not nearly so welcoming to science. In fact, it resists science in a big, big way. This science on basic police work, we have years of it. It is rigorous, it is published, it is peer-reviewed, it is practical as well. I mean, it points out the problems with the way we do things, and for instance, eyewitness identification, and it gives us answers. Here is a way to switch and change the procedures so you don't get the problems that we have had exposed over the last 15 or 20 years. And yet, most, certainly not all, but most of law enforcement resists this science. At best, doesn't recalibrate its practices to reflect what we now know from years and years and even decades of science. And what we get instead of justice in too many cases is failed evidence, evidence that does not do what we think it does. So let me take you back into how we know this, what we know now, but then let's focus on what I think are the real questions. Why is there such resistance to science across most of what is out there concerning the basics of law enforcement? And if we can understand why the resistance, maybe we'll be able to figure out some ways to break through it, and I have some examples for you. So that's where we're going. All right, first step is to figure out how we got where we are. It has now been more than 20 years since the beginning of what I think you can legitimately call the DNA revolution, where we can use DNA as a scientific tool to identify with a great deal of precision and power those who commit crimes. In that 22 or more year period, we have had 300, now more, I'm told since I made this slide, 300 post-conviction DNA exonerations, 300 since 1989. In that period, here's how those things break down. This is what you see in these 300 cases, and every indication we have is that these 300 are just the tip of the iceberg, because you don't get DNA in but a fraction, a small percentage of all cases. But in these 300 cases, here is what we see. Number one, 72% of all of those cases feature a faulty eyewitness identification. 72%, almost three-quarters. Half feature some kind of faulty forensic work. Sometimes it's outright fraud, and sometimes it's just bad science or no science at all. And more than a quarter, 27% of cases feature a false identification or false statements made, false statements of guilt. All right? Now, these add up to more than 100%. Why? Because plenty of cases feature more than one type of error. But this is the pattern across those DNA exonerations. And so what you see is a different world. What this resulted in, once DNA came on the scene, it's all of a sudden there were lots of questions that didn't used to come up before. Hey, wait a minute. I thought people didn't confess to stuff they didn't do. I mean, I would have believed that, but now we know it's not true. I thought fingerprints were the gold standard. Oh, maybe not. So let's take just a minute and look at a little bit of what this science tells us now that we know about some of the basics of police work. So now we move from DNA to what DNA has showed us over the course of time. So we'll pick one out here, eyewitness identification. This is probably the place within science and police work where there's been the most science, the longest period of time, the greatest number of substantiated new claims, articles, and so forth. And let's start with an idea, simultaneous lineups. You've all seen simultaneous lineups. Okay, this is a simultaneous lineup. The 5 people, 6 people, 7 people, whatever it is, they're standing together, simultaneously presented to the witness, as in the picture that you see here. It turns out that this procedure introduces a certain level of error into the eyewitness identification process because the witness's mind is automatically put in the following frame. Which of the people I see here looks the most like the guy who robbed me? Now, if the guy who robbed them is one of those 5, great. But if not, somebody else looks the most like that person. All right? You could see why that would be a problem. So that introduces a certain level of error. So what we do instead is, the research tells us, move to sequential lineups. And that error is almost taken out of the picture entirely. So if that's a simultaneous lineup, here is an example of a sequential lineup. Here's a simultaneous lineup of photographs on the left side. In a sequential lineup, the witness is shown one person or one photograph at a time. Same 6 people. Doesn't have to change at all. We just show them one at a time because then the mind works different. And instead of who looks the most like the guy, it's, is that the guy? Is that the guy? And that's much more accurate. All right? Proven out through study after study. Another example from the eyewitness identification area, blind lineups. Blind lineups. Now, it turns out most times when police are showing a witness a lineup, it is the officer who has been in charge of the case who does that, who administers the lineup to the witness. And that person, because they're in charge of the case, knows who the quote-unquote right choice is in the lineup, who the suspect is. And when that's the case, we get a certain level of error introduced because that police officer, without intending, without knowing, without being conscious of it, gives very subtle signals to the witness as to which the right choice is. So a certain level of error is introduced. And it's not anything about the police officer's integrity. It is a human thinking process. So here is a regular lineup being shown by police officers. If we have in this photograph, if these 2 gentlemen are police officers who are involved in the case, that's the witness looking through the glass at the lineup. That will introduce a certain amount of error. It turns out, the research tells us, all we got to do to fix this is put a different police officer in that position, somebody who doesn't know the case. It could even be a civilian. It could be anybody to run the lineup, and that effect disappears. You got this, what you see in the photograph, is the traditional way of doing things. So there's the research showing us, here's the problem, here's the fix. And you see this across various aspects of basic police work. In interrogations, like I said, you could not have convinced me 25 years ago that people would confess to a serious crime that they did not do. And yet now the evidence is overwhelming that they do. And they do this without physical abuse, without any kind of mental deficit, and without a lack of sobriety. Those things make it worse, obviously. But even without those things, people confess to stuff they didn't do. And the research is clear. How come? Various kinds of significant pressure that the police put on you. And a lot of that stuff is allowed, or they can go up to the line. Now, what do? The solutions? Record. Very simple. Record. Record every interrogation front to back, from the beginning of the questioning to the end. What else can you do? The research tells us you shouldn't be allowed to lie about scientific testing. All of you who are lawyers or have taken criminal procedure, you know that the police are allowed to lie during interrogations. It just turns out some lies are way more equal than others. Okay? So to say to somebody in an interrogation room, your buddy in the next room is giving you up, time to speak up, is way different than saying, we found your DNA on the guy's shoe. In the second, the person will feel trapped, might know they didn't do it, but is likely to do anything to get out of that situation, including confess. Forensics, and this is non-DNA, non-chemical analysis type forensics. It turns out the science on this is really kind of earth-shaking. There was a 2009 report by the National Academy of Sciences on forensic science in the United States. It turns out, this report said, in its very gentle, bureaucratic language, most of this stuff isn't science at all. Not in any true sense of that word, because it's not using data. It is using human interpretation and judgment, which is not to say it's always wrong. No, no. It's usually right, but not always. All right? And typically, forensic laboratories take very few of the standard precautions against human biases. They don't do blind testing. They don't do proficiency testing, all kinds of other things that we can talk about if you want. You could ask this guy if you're interested. This is Brandon Mayfield, the guy, the attorney from Oregon, who was named by the FBI as the suspect in the Madrid train bombings in 2005, based on that smudgy fingerprint you see all the way at the side of the screen that the Spanish police put out over the Interpol lines. The FBI got a hold of that, figured out that Brandon Mayfield, who had fingerprints in the national system because he was in the military, he'd also been arrested at 17, they said 100% match after they found out that Mr. Mayfield was a member of a mosque in Portland where there had been a terrorism case of some magnitude years past, completely unrelated. The FBI had him locked up, pronounced it 100% match, got the top guy at the FBI lab to come 100% match, retired guy 100% match, outside expert 100% match, until it wasn't. And the Spanish police arrested the right guy 2 weeks later. This is actually what triggered the 2009 National Academy's report. All right? So, not what it seems. And the science tells us we could do a lot of easy stuff to fix what we do in forensics. All right? So, if that's what the science tells us, both spotting the problems and giving us some solutions, why the resistance? Well, I figured there's no substitute for nothing that would compare to going right to the source, to asking people in law enforcement, why do they not get on the bandwagon with some of this stuff? And some of them have. I want to be clear. A small number of departments and states, growing but still very small, have made significant changes, and I think there will be more of that. I'm going to say more about that later. But it's still the overwhelming consensus in law enforcement that they don't have to do anything. So I figured, why? Here are the 5 things I heard over and over. Number 1, science from labs doesn't mean anything to police work on the street. Police work is an experiential street-level job, and science out of a lab has no relation to it. Don't even talk to me. Number 2, science isn't dependable. It's constantly changing. I mean, how many times did you wake up and turn on the TV or the radio and they say, eggs are bad for you, don't eat any eggs. And then you turn it on the next day and it says, eat all the eggs you can. You know, new study, right? Oh, and social science? Don't make me laugh. Right? That stuff, that could say anything. Right? And frankly, a lot of the science in these areas comes from cognitive psych, not hard sciences, so-called, and so it gets laughed at. Number 3, it's just too expensive to change. Number 4, this is just a way of saying that you think law enforcement is corrupt. That's really what you're saying. And number 5, don't forget this. This is just tricks for clever defense attorneys to get the guilty off. Well, I'm going to cut to the chase on this stuff. You push on any of these things, there's nothing there. All right? None of these things carry any real force. What you have, what really accounts for this resistance, from what I've been able to figure out, is 2 main things. You have 2 sets of barriers, and that's what I want to talk about now. One set of barriers is cognitive. The other is institutional or political. All right? Cognitive barriers and institutional barriers. So let's take the cognitive barriers first. These are the real reasons you don't get any motion towards change and you get active resistance. Many different aspects of cognitive science account for this, but these are the ones that really stood out to me. Cognitive dissonance. Group polarization, the idea that when a group, say police officers, there may be a spectrum of opinion among police officers like there is in any professional group, but when they get together, they talk to themselves, the discussion tends to polarize to the extremes. Behavioral economics, a lot of good, understandable work here that I think explains a lot. Loss aversion, it's much more difficult to get people to change, it turns out, because people are much more concerned about what they would lose in a situation of change than the possibility of what they might gain. The status quo bias. Everybody is biased towards the status quo. These are the kind of things that keep change from happening, and they are especially active in this world of law enforcement and science. Let me just pull one out and talk about it in a little detail. Let me talk about cognitive dissonance, because I do think this is probably the most powerful of these cognitive forces. Cognitive dissonance is probably a phrase that many of you have heard. Go back to Psych 101 if you can remember back that far. The idea is if a human being has two sort of opposite truths or cognitions, thoughts, those create a tension, and it must be resolved. There is a dissonance, a tension. And the human organism will actually feel it physically, and you will have to resolve that. All right? So when you have a cognitive dissonance, you're going to have to do something about it. That usually involves rationalizing away one of the cognitions, right? So let me give you an example that I bet most of you can relate to. Let's say you're a smoker. I'm not, but let's say I was. Say I smoke 2 packs a day. I'm a smoker. Let's say, on the other hand, I also know, since I'm awake, I'm alive, I'm reasonably intelligent, it's only 50 years after the Surgeon General's report, this stuff causes cancer, causes emphysema, the secondhand smoke makes people in my house sick, my kid with asthma can't breathe, et cetera, et cetera. Two opposite cognitions. I'm a smoker, and smoking is really bad, and I shouldn't do it. How do I resolve that tension? I rationalize, right? So what do? Okay, well, when I smoke, I eat less. And obesity is another big, important health factor. So it all kind of evens out. I'm cool. Or 2 packs a day? My old man smoked 3 packs a day, and he lived till he was 90. It's all good. Right? Those are rationalizations. They get you past the dissonance. Now, how does this work in law enforcement? And I saw this many, many times. The dominant thought in law enforcement, whether you're a police officer or a prosecutor, is we are the good guys. We do the good work. We put the bad guys away. We protect the good people. This is who we are, and it's what we do. And we are on the side of right. Now, that is not wrong. That is true. That is why people get into police work. It's why people become prosecutors. That is what they believe in a big and a deep way. But on the other hand, over the last 20 years, if you were awake and conscious, you can't miss the fact that sometimes catastrophic outcomes have happened in the criminal justice system, even when people are following all the rules, even when they're going by the regular procedures. Things fall apart in a big way, and we get people going to death row and to long prison terms for stuff they didn't do. And like I said, we know about it in the DNA cases because there's almost irrefutable proof. There's lots of other cases where you'd expect this is happening too. All right? So those are two really opposite cognitions. We're the good guys, and we're putting the wrong people in jail, even if it's only sometimes. And can we live with that? What happens? Rationalization. Here's what I hear. 300 cases with DNA? You know how many cases there are in the system every year? 300 is hardly anything. It's a very small number. Or 300 cases, DNA exonerations, hey, the system worked. That's the kind of thing I'm talking about. That's a rationalization. That takes away the tension. All right? So these kinds of things are very, very hard to overcome. What about those institutional and political barriers? Whoops, I went the wrong way. Here we are. All right. A whole bunch of things here account for the resistance of both police and prosecutors, law enforcement, to the science that is out there available and really not controversial amongst those who do the scientific work. Point number one, the imperatives of arrest and conviction. All right? If you're a police officer, the most important thing you can do to get noticed, to get your career advanced, to be thought of as a good, proactive officer, are to close cases by arrest. Make a lot of arrests. Police officers who don't make a lot of arrests are not held up in super high esteem in many police departments. And it's a metric. It can be measured. All right? Prosecutors, many times the same thing. Conviction rates. Now, anything that looks like it might get in the way of those is not going to be looked on favorably. It is going to be resisted. It is going to be a situation where people pull back from it and are suspicious of it. Right? That is reality. Now, other professions, other areas of work have their own imperatives, and you get resistance there too. But remember, what we're talking about is public safety and the work of the courts. So there's a lot at stake here. Point number two, the police culture. And I could say this about prosecutors too. I think it's also true, though with prosecutors, they're also members of the legal profession generally, so maybe not as strong. But the police culture is incredibly strong, incredibly hard to penetrate, and it's very much an us versus them world. Right? If you haven't worn the uniform, you don't wear the badge, you don't have the responsibilities, who are you to tell us what to do? Who are you? You're some judge up there, you're some professor over here, you don't know anything. It's like Jack Nicholson in A Few Good Men. You can't handle the truth. Right? And so there's massive resistance to suggestions coming from anywhere else. All right? Plenty of other things here. All of this slows down and even stops the possibility of change. All right? These are the reasons why years and years into the research, decades into the eyewitness testimony, eyewitness identification research, decades into research on interrogation techniques and so forth, we still have police departments doing investigations according to procedures that are making mistakes that we're going to find out about maybe in 10 more years. So this is the kind of thing that I think you have to pay attention to. So if we know why the resistance is there, does that make it any easier to try to break through? Well, I suppose one question is, okay, if you could break through, what would you want? And here, this is actually a fairly easy question because there's so much, really, like I said, non-controversial science out there about what would be better practices based on the research that already exists. You'd go to sequential lineups. You'd go to blind lineups. You'd record all your interrogation. You'd ban lies about scientific testing. You'd use data-based forensic procedures, not human judgment-based procedures. You would put bias safeguards into every single forensic laboratory. And some of these sciences, so-called from forensic laboratories like bite marks and some other things, those should just be tossed into the bin. Those things are dangerous. They don't work. So the changes, I think, are not hard to spot. The question, of course, is how do we make it happen? Right? That's the only question. How do we break through? How do we make it happen? And this is difficult. With those kind of barriers, it won't be easy. That we know for sure. So let me give you 6 ideas that I think can help and that I have actually seen work in some places to make these kinds of changes a reality. So, point number 1. Let's focus on the future and not on the past, with an important caveat. Okay? Here's what I mean. Focus on the future and not on the past. The energy, the work that has gone into the DNA exoneration and so-called innocence movements over the last 20 years has largely been focused on particular cases in which there's been some kind of massive injustice and there's some kind of proof out there. That is as it should be. There's no other way a system can call itself a system of justice if it doesn't work to fix those things. But what that has done is focus much of the discussion on who was to blame and what happened and how did things break down in any individual cases. And and it has not allowed people who are interested in change to focus forward and say, how do we prevent this from happening again? At least not enough. Not enough. What I envision instead is a focus on those reforms that can allow us to fix things going forward, with this important caveat. There must be built-in hardware in the system, in the criminal justice system, to take care of, to focus on, to investigate, root out injustices in prior convictions. And the one I have down here is conviction integrity units. In some forward-looking prosecutors' offices starting a few years back in Dallas, Texas, then in Houston, now in the Manhattan DA's office, and now in a few others, DAs have established what they call conviction integrity units. And these are dedicated units, just like a narcotics unit or a homicide unit within the DA's office. And the job of that unit, or even a single lawyer, is to focus on cases in which there is a legitimate claim of innocence or of misconduct in the past. That's got to be part of the built-in mechanisms of prosecution work. Conviction integrity units is one way. You could establish an outside agency, as North Carolina has done. That's another way. But I'll take conviction integrity units now because prosecutors can simply say, we're having one of those. And these things work. These things work. The records in Dallas and Houston and many other places are quite clear that they work well. And once that is there, once there is an established mechanism, once it's part of the wallpaper or the furniture, whatever your choice of analogy, when that's regular business, we can focus ahead. And we can ask ourselves, what will keep this from happening again? Number two, police and prosecutors in the lead. They have to lead this effort. I'd love it if everybody wanted me to lead this. I mean, who wouldn't want that, right? Right? I've got it all figured out. But who listens to an academic when it comes to the law enforcement world? I've been there. I've been training police and prosecutors for a long, long time. I am under no illusions that I get invited, I get a nice pat on the head and a coffee mug, and, thanks for coming. Hopefully it's a little more than that, but if you want real change, you want people that they're going to listen to and actually take their opinions and take them extremely seriously, you get police officers and prosecutors from those few states and departments that have been doing this for a while, and you make them the leaders of the movement for change. And like I said, there is a small, growing but small number of people with extensive experience with every reform that I have mentioned here this morning, every single one. All right? So, for instance, in Minnesota, they have been taping interrogations in full for almost 20 years. This is the 19th year. They have a lot of experience with it. You know what they think? They love it. They love it. My favorite quote, the thing I came up with that I like the most, police captain up in Minnesota says, taping interrogations, that was the best reform that ever got shoved down our throats. Right? That captures the spirit of it. They didn't want it. Their Supreme Court said, oh, no, you're going to do this in every case. And they do. And it turns out it helps them immensely. When that guy gets in front of an audience of police officers, he's going to get a different kind of hearing than I would. Right? And there are, like I said, there are prosecutors and police officers now with this experience. Number three, we need champions from the right, not just from the left. That may seem a little counterintuitive. I mean, the people who have sympathy for the arguments I've made often come from the left side of the political spectrum, the left side of the legislature, if your state has one. Those are the natural allies, right? But in fact, where I have seen change occur, it is almost always because there was a champion on the right who took up the cause and actually made it happen. I'm going to give you an example in just a minute. But that kind of a person will not get challenged in the next election cycle. Senator so-and-so is soft on crime. Can't you just hear the commercials if you come from the left side of the spectrum? Whereas the person who's been chair of the State Judiciary Committee, voted for all the prison expansion and everything else, now is with this, that person's not worried. That person is going to actually have political courage to go ahead and do this sort of thing. It's Nixon going to China, for those of you who remember Nixon. It's that kind of thing, all right? Number four, U.S. Department of Justice gives out money, not to you and me, but to police departments all over the United States, big and small, in the form of grants. Every year, it's tough to find a police department that isn't getting some DOJ money. Attached strings. And when I say money, I don't mean $5. I mean, they're giving away billions of dollars every year, even in the current budget climate. You just tell them, look, you want this money? Let's have these best practices. Oh, don't want to do that? Okay, do without our money. Right? I remember this working very well for the 55-mile-an-hour speed limit. All right, remember that? And I didn't say the 55-mile-an-hour limit was good, but the federal government got every state to do it, almost every state. Right? They did the same thing with highway money and the drunk driving threshold. So this is just the power of the purse. It's foolish not to do it. Number 5, preserve evidence. Preserve evidence. Right? There are people walking the earth today who would have been executed. There are people walking around free today that would still be in jail, if not for the completely fortuitous accident that evidence from their cases in the 70s or early 80s was preserved, and then DNA showed up in 1989, and they were proved innocent. Plenty of states, locations, jurisdictions preserve evidence long-term, but many of them don't. And those of you who've studied this know the U.S. Supreme Court has said that ain't a constitutional rule. No state has a constitutional obligation to preserve evidence in some, ongoing way. But if it's not a constitutional imperative, it is clearly a moral imperative. When we know that this is, that technology is advancing, and who knows what we'll be able to do in 5 years or 10 years, we've got to do this. I mean, this is a moral imperative. We can't walk around and not do this. Last point on the ways to get through it, judges and defense lawyers. I'm talking to you. I've talked a lot about police officers and prosecutors, and I think that's right, that the burden is there because they collect the evidence and they use the evidence and bring it to court. But defense lawyers and judges, you have an important role here too. You know that case in evidence, the Daubert case, right? One that says judges have to be gatekeepers against junk science. Well, here's what the science says about that. The research is pretty clear that judges do a pretty good job of keeping junk science out of courts. In civil cases, where it's brought by plaintiffs who want to prove a big product liability claim, a breast implants case, something like that. They're great, the judges are, at filtering out the junk and keeping more of it out than they let in. Criminal side, not so interested, it turns out. They're not interested in the science that shows that there's less to fingerprinting than meets what we always thought. They're not that interested in challenges to forensics in general. And they got to get interested. Clearly, you read Daubert, you can read it up, down, sideways. Fingerprints are in trouble under Daubert, or they should be. And that's not all to the good. We need something to replace that. We need that science to get better. But it won't get better if judges keep accepting the same 100% accurate, zero error rate testimony from fingerprint experts, which they in large do. Defense lawyers, you got to wake the judges up. You do. I mean, you got to just, hey, I got another one of those crazy motions you always deny, but I'm going to keep it up until I can get you educated. All right? You got to keep doing this. All right. One quick example before we stop for questions. Meet Beverly Lake. Chief Justice Beverly Lake of the North Carolina Supreme Court, now former Chief Justice. This is by far the most interesting interview I did for the whole book. Chief Justice Lake was, like everybody else, watching through the first decade of our century as his state, like so many others, had DNA exoneration cases, one after the other. Not so many as some other states. North Carolina was no Texas, but it had plenty of exonerations. And roughly the same time, in the same span of years, Justice Lake took on a law clerk who was very interested and had actually done a couple of DNA exoneration cases. And they began to talk about this, And from Justice Lake's point of view, there was a very serious problem. That problem was the integrity of the system. He felt that that was at risk. And Justice Lake was at very great pains to explain to me and be, very emphatic. He was a conservative, he wanted me to know. A real conservative. He said, I was converted to the modern Republican Party in North Carolina by Jesse Helms. How's that? I've been to counsel to the governor, and I was the liaison to the legislature, and blah, blah, blah. He was all about how conservative he was. But this bothered him. And his take on this issue was a little different than others I had heard. He said, the integrity of the system is at stake, and here's my concern. I believe, he told me, in the death penalty. I believe it in my bones. I believe that people in North Carolina need the death penalty. And my great fear is that if the integrity of the system comes under deep questioning for too long, we will never get another death verdict out of a jury in this state, and I can't live with that. Well, look, that's not my take. Maybe it's not yours, but it certainly was his. And he was the guy who organized the entire effort in North Carolina, which now has the first, and as far as I know only, actual innocence government body. It is a body that has the power to exonerate in cases in which there are questions of actual innocence. The only other place this exists is in the UK. It was modeled on a procedure in the UK. They now have new eyewitness identification procedures in North Carolina because of him. He could bring everybody around the table, both sides. He had the prestige. He was that guy leading from the right. He was as close to law enforcement as you're ever going to find on the bench. Right? He was the guy. And there are other people like him who I will not talk about because of the press of time. So, just to sum up, I want to make clear to you, I am not looking for perfection from the criminal justice system. Woe be unto anybody on that journey, because you won't find it. All right? I never did. But I think we can do better. There is no question that we can do better simply by paying more attention to what science has already established and having the courage to go along with it and try it and get accustomed to it. I remember years and years ago reading that when the Miranda decision first came out, it was, the sky's falling, never another conviction, no more confessions. That didn't work out that way. And I think these changes would be the same thing. You see this in Minnesota and other places. Police know how to work with better procedures, and they benefit by those procedures. Now, it's not going to be easy, but we can do it if we have the will to do it. So, I thank you for your attention. I'm ready for your questions. Questions? Yes, sir.
Yes, you focused, of course, on the acceptance of science and behavioral science, and I really appreciate that you focused on behavioral science, in particular by law enforcement. Given my background, I'd be curious what your thoughts are in terms of the acceptance of the legal community in general of behavioral science and their understanding of science. And you know that, of course, there's this great interest right now in functional neuroimaging as kind of a way to truth. But at the same time, I sense in the legal community in general a fair amount of dismissiveness with regard to kinds of studies such as simultaneous versus sequential eyewitness identification, even though that's been very reliable in terms of study after study going into the same.
Great question. Great couple of questions, I should say. I think the legal community as a whole is remarkably incurious about most of it. We just don't understand it. We don't have the tools for it. We didn't go to school for that. Hey, I thought if I took this political science major and went to law school, I'd never have to take another science course. Right? And we are unaware, I find, of the basics of what behavioral science is about, and very much unaware of the breakthroughs in behavioral sciences over the last 10, 20, even 30 years that have a direct bearing on what lawyers do in general, let alone what police do. One of the reasons, for instance, I teach evidence. One of the reasons I chose the book I chose for my course was that every few pages, every chapter, there's at least one excerpt from some kind of behavioral science article, because I think it's important that students get exposed to that. There's more curiosity and more ability now among students that are coming up. We have a course at Pitt called Behavior in the Law, which talks about all these things. But basically, it's, we're not set up for it, and we're not curious enough, and we got other things to do. And the fMRI thing that you mentioned is a really great example. My great fear is because we're so incurious, we, lawyers and judges, are going to simply accept this as the new, quote, lie detector. I don't know how many of you have seen this, but there's an outfit set up called No Lie MRI, right? Your MRI can tell you if you're lying. Well, no, it can't, actually. And I'm afraid that this is going to get accepted in court because we don't have any idea what we're doing. Right? And it's going to be whiz, bang, flash, and all of a sudden we'll be saddled with that. Yes, sir? Yeah?
What about the independent labs for forensics and DNA? Most of the time, the prosecutor in this case runs those labs. In some areas, they're independent. You can talk about.
Yes, yes. What the gentleman is referring to, there are literally hundreds, maybe thousands, of forensic labs in this country. We know about the county lab and the city lab or the state lab and the FBI lab, but there are lots of even mom and pops out there. Among the government-run labs, the large majority of them are kind of wholly owned subsidiaries of the police department, the prosecutor's office, the blank state Department of Public Safety. There's a problem with this. Anytime you are set up that way, the normal human desire is to please the boss. That's putting it in very simple terms, but I think it carries over. And there have been multiple scandals involving forensic labs. I don't know how many of you track this, but God, it just seems like every other week there's another one in some area of the country. Now, for the most part, let me just go back one step. The 2009 National Academy of Sciences report, that was one of its main recommendations. Forensic labs should be independent. In other words, they shouldn't answer to the police or prosecutor for their work. They should simply be like a utility for any aspect of government, defense, prosecution, whatever. Independent. We'll get better work out of them. Now, that isn't to say you never have problems out of independent labs. Sometimes you do. Great big crime lab scandal in Massachusetts this past summer. That lab had just become independent for a year, and it still blew up. Maybe the problems were of longer standing. But in general, that suggestion has been among the most tenaciously resisted of all the things I've seen. I didn't talk about it here, but the reaction to the idea that labs should be divested from police departments and prosecutors' offices and made into independent agencies has just been fiercely resisted by every level of law enforcement that I have come up with, that I have encountered, I should say. It'll be inconvenient. How can we talk to them about cases? What if I need to, and those are sometimes precisely the problems. So it's a change whose time has come a long time ago, in fact, and is slowly beginning to happen, just not fast enough.
You talk about things like breathalyzer. Told in many states it's a black box. It's a trade secret. There's all issues like how it works, the process by which it works. You load something, magically a number comes out, you either guilty or innocent based on this number. Can you have real science when the technology is not subject to rigorous independent scrutiny, verification, and have a hypothesis that can be tested or disproved?
Professor Givens is asking about breathalyzers, which for all intents and purposes, for those of us down in the court system, and I speak as one who's tried many DWI cases on both sides, is a black box. Guy blows in, a number comes out. What's been really interesting to me is watching this over the last few years from a different point of view of the law, the confrontation clause. The thing that in the Constitution that says you have a right to confront the witnesses against you has broken open a whole bunch of issues with regard to when do you have to have a witness in court to testify about what the heck is going on in one of these black boxes. And the Supreme Court, though it's quite confused about all this and made more confusion last year, the Supreme Court has generally said you can't just have the numbers show up without the technician. The technician's got to be there. They got to explain calibration. They got to be able to explain the formula that's going on in there, the chemical reaction, and so forth. So, as regard to those kind of black boxes, the Confrontation Clause, of all things, is actually giving us sort of hope that that stuff will be more opened up. But anything like that, it's sort of incumbent on the defense attorney, as I see it, having been one, to know what's in that box, whether it's told to you or not. You got to climb in there, figure it out, and start cross-examining at the very least. Sir.
I have a comment that will lead to a question. And I represent law enforcement, and I think I'm probably in the minority here.
Does everybody know Mike Navarre, former chief of Toledo Police?
We've known each other for many years.
Yes, sir.
Respect for you. My issue when this subject is discussed is that reasonable doubt to some people equates to innocence. And that's not the case.
You're right.
And I will acknowledge that of those 300 DNA exoneration cases, that there are innocent people among those 300. But I will ask you, will you acknowledge that among those 300 there are some guilty people? Because just because you don't find the suspect's DNA on the victim, and just because that DNA is not in a female's body cavity, that does not equate to innocence. That might create a reasonable doubt, and that may have released that person from prison. That does not equate to innocence. And we are, in fact, there are some of those that are, in fact, guilty. You have to accept that.
May I, would you like me to respond? Yeah. I do accept that. I accept the point that some of those cases could, I wouldn't know which ones or how many, I tend to think it's a smaller number maybe than a larger one, that we would disagree about that. But there are a host of cases in which there is a finding of innocence based on the lack of DNA plus the fact that other physical circumstances that were supposed to support the conviction simply are inconsistent with what the DNA shows. So it isn't only the DNA, I don't think. Now, to push the point a little further, what's coming in the next 5 to 10 years is going to put some of these questions, I think, behind us, where there is DNA to be tested. I've sort of portrayed the world as being upended by DNA from 1989 onward, all the regular stuff we used to do. DNA sort of putting the lie to this thing after the next thing after the next thing. DNA is about to experience its own DNA revolution, or DNA moment, if you like. And what I mean is this. There is, right now, there are new procedures available, not yet accepted by American law enforcement, but accepted in some other parts of the world, that not only will allow testing on smaller samples, that's been happening for a long time, but the tools that will be used to do the analysis are about to be, that will be coming into use, are about to become much more powerful than the DNA we have now. And so you will get, you know, we're accustomed now to thinking, wow, it's huge. The odds against it being anybody else are 87 million to 1. The numbers, the odds ratios, the likelihoods ratios are about to go up into the trillions and quadrillions. And the DNA will be able to pull apart mixtures of DNA in ways that it could not before. So what we're going to see is an explosion in both exonerations and findings of guilt. Because some people are walking away who shouldn't, just because the DNA doesn't show it's them. Again, we can disagree about the numbers, but that's what's ahead. That's what's ahead. And that is what I look for as something that will kind of pick up the slack where some of these other forensic disciplines are just, they're not good enough. Yes, sir.
There's a case going on now, former police chief in Akron just got released arrested in 1998.
Oh, the forensic dentistry case. Yes, yes. This is an amazing case. He was arrested, and convicted based on bite mark analysis. This science is you take a picture or an image or a cast of the bite mark on the body, and then you match it to the person's teeth. Let's just say this doesn't work. All right? We could say more, but let's just leave it at that. And there are plenty of people, they're slowly getting them out of jail, including this man. Now, to take Chief Navarro's point, guilty or not, I don't know. But that evidence, that isn't what you could use to put him in. I don't know anything else about the case. But that's an example of the kind of so-called science that's been accepted and must be rooted out. It's not doing anybody any favors. There's a lot of arson evidence these days. The same sort of thing. If you've ever read about the case of Cameron Willingham in Texas, I invite you to do that. The arson investigation that put him on death row, he's not executed for killing his children in an arson fire, was deeply, deeply flawed. The arson investigation was described later on as based on folk wisdom. I don't think any of us wants that. Do we have time for
One more question.
Yes. I really have sort of a bank shot question that I want to put it to Mike and then a comment. I believe it was under Mike's reign as chief that recorded witness and defendant statements, audio and visual recordings are made of every interrogation. Much to your credit, Mike. I'm curious to know whether there was resistance prior to that by your detectives, and how they reacted after you caused them to record all of these interviews. I mean, did it do what Miranda did, where we ended up saying, well, that's okay, that's just good for this one. We don't mind recording these interviews. And just as an aside, Mike made his detectives record everything. The FBI to this day does not record even audio, just audio. They want to rely on their notes that go into the 302s. So it is the FBI special agent's recollection of the interview that we have to do.
What a thing.
Yeah.
You care to comment?
Well, there's always going to be resistance to change. What was surprising about that is there was more resistance to that change from the prosecutor's office than there was from the detectives. But that went away really quick because they found out what a valuable tool that was for the court presentation. So I think everyone has fully embraced that now.
If you didn't hear that answer, Chief Navarro said there was resistance, but far more from the prosecutors than police officers, consistent with what I found too. And now everybody's kind of embraced it.
We've come to the end. Please join me in thanking Professor Harris for this fascinating talk.